Controversy is the invocation of Article 97 of the 1992 Constitution, which calls for MPs who change their party affiliation or contest as independents to vacate their seats. Now, this issue has sparked heated debate, with the opposition NDC arguing that these MP seats must be declared vacant, potentially allowing them to secure a majority in Parliament, like we've seen. With the latest Supreme Court ruling suspending indefinitely the Speaker's decision to declare the seats vacant, we ask, what's next? I'm Kamini Amano, and this is Hot Issues. In this episode, we explore the constitutional, political, and electoral ramifications of this ruling, which will likely create a parliamentary standoff. My guest and I will unpack the stakes and discuss what this means for governance in the lead-up to the 2024 elections. My guest is former Deputy Attorney General and Bogotanga East MP, Dr. Dominic Ayene. Doc, you're welcome to Hot Issues.
Thank you very much for having me, Kamini.
Where will your side sit on Tuesday when you reconvene?
Well, ordinarily, we should be sitting at the majority side because from the Speaker's ruling, we have 136 members and the New Patriotic Party has 135 members. So they are in the minority. But of course, the orders of the Supreme Court will have to be implemented. I don't know how long it's going to take for Mr. Speaker to implement it. If he's implementing the orders from day one, then it means that we revert to the position in which we were, which means that we will not move to the majority side. But if he's not implementing it on Tuesday, then we will, be on the majority side until such a time that he announces that he has started the implementation. Because I believe Mr. Speaker is going to instruct his lawyers to, as a matter of urgency, file processes on Monday to try to set aside the orders of the Supreme Court. I think that is what is going to happen. I spoke to Mr. Speaker's lawyer, Mr. Tadio Sori, before I came to the studio, right. When I knew that we were going to be discussing some of these issues. So definitely, I believe that Mr. Speaker's instructions will include expeditious filing on Monday to be able to contest the orders that have been made by the Supreme Court. Because as I said, ex parte orders are an aberration, especially when they are being issued against another branch of government, and especially a co-equal branch of government. The courtesy should have been extended to Mr. Speaker so that his lawyers will come to court to contest the injunction application on its merits. All right. Now, Mr. Speaker has, performed a public function, by informing the House, pursuant to Order 18 of the Standing Orders of Parliament, of the occurrence of a vacancy, right? And there are public duties flowing from that will ensue from Tuesday. Now, to enjoin the performance of those public duties, is unusual. I mean, the courts have been very, very clear that you don't enjoin the performance of a public, duty. But of course, I think the lawyers for the Honorable Afenyo Makin basically use the specter of deprivation of representation, as the basis. As if in 2020, when they decided to write for the Fomena MP, situation. To be recognized in Parliament, the people of Fomena were they not deprived of representation? Of course, does that sound hypocritical for you? Yeah, it is. It is very. They are exhibiting double standards. All right. And that's typical of the MPP. Part of the problems we have had in this country, with our democracy, is what I call the MPP exceptionalism. They always want to be an exception. So they were the ones who engineered the processes leading to the removal, if I may say so, or the declaration of a vacancy, the occurrence of a vacancy as far as Fomena was concerned. And then today they turn around and say, no. Yes, we did it in the past, but it was wrong.
The snippets of the Supreme Court ruling that you have heard, do you also get the impression it would appear as though they had ruled on the substantive case instead of ruling on an ex-parte.
You are spot on. I think they sounded to me, and again, I must enter the caveat that I haven't read, the ruling in its, and I mean, fully. Okay, what I am commenting on is based upon journalistic accounts that are on social and mainstream media. But they sound to me like final orders. For instance, to say the ruling of the speaker will deprive them of representation means you are simply saying that what Mr. Speaker has done, all right, undercuts the concept or practice of representation, contemplated under the Constitution. And that's why I said earlier that the deprivation of representation is contemplated under Article 97, and it is not a constitutional anomaly, right? So, for instance, if I write to resign today, okay, 3 months to an election, the people of Bolga East, will be deprived of representation, but it is something that is contemplated under Article 97 of the Constitution.
Would you then say that the Supreme Court was wrong in its decision?
I need to read it before, but I think that they are wrong. If you use the concept of representation as the basis to say that not even for one day should somebody be not represented in Parliament, even when they have conducted themselves in a way that violates the Constitution of the Republic of Ghana, right? Then I think that is wrong. Because, for instance, if you take Cynthia Morrison, I'm just giving her as an example. I'm not saying, she's declared herself an independent candidate. She has proceeded to the Electoral Commission to file her nomination as an independent candidate. She's in the constituency, as we speak, campaigning against the New Patriotic Party. Okay? Then she comes to Parliament, and you say it is okay. She can go and sit on the side of the New Patriotic Party and then pretend that she's legitimately a member of the New Patriotic Party. That gives them a majority over the NDC, right? Because under the MPP's own constitution, particularly, specifically Article 3, immediately you file as an independent, you lose your membership of the party. It's automatic. So Cynthia Morrison, the Honorable Cynthia Morrison, she's my colleague and friend, is no longer a member of the New Patriotic Party. What business does she have sitting on that side and voting with them?
And then in your case, you have the Amenfi Central.
Amenfi Central.
Yes.
He is in the constituency campaigning against our candidate. The NDC's candidate for Amenfi Central is, Joanna Jan Kujo. Okay. The Honorable Aka is in the constituency campaigning against our candidate. And then you say that it is okay for him to come and join our side and then, say that he's a legitimate member of the party and he's, working with us in Parliament.
Sounds like this ruling is going to create chaotic scenes in Parliament for the next 2 months if it stays.
Well, it will not have created any. You mean the ruling of the Supreme Court?
The ruling of the Supreme Court.
Of course, it is going to, as I said, I keep saying it's going to take us back, one step back from where we came from, but I'm hoping that eventually, the dust will settle. Indeed. And we will know where the Constitution is.
Because now you are having to, your side in Parliament would have to put up with, a person who is, like you said, is campaigning against your candidate in Amenfi Central.
Right.
Even the NPP side will also have to contend with 3 people who have said their parting ways with the party. Very uncomfortable situation. Can the business of Parliament go on with in the center of this scenario?
No, it's because, Kemini, we conduct politics of convenience and not politics of principle. And that is where, that is what is driving us into this type of crisis. Okay, because if we were conducting politics of principle, okay, we should not be entertaining the MPs that you have named within our midst. Because in principle, they have quit, their positions as members of the respective parties by filing to run as independents. All right, and also, in the case of the second deputy speaker, another very good friend of mine, okay, he has decided to join the New Patriotic Party, so he's no longer an independent. So if we're conducting, politics according to principle, you know, they should not be coming to Parliament. The MPP should have accepted that vacancies have occurred, the balance of power in Parliament has shifted, and then all of us would have been happy, you know, working with each other to conduct the business of state, you know, and then for Parliament to be dissolved on the, 6th of January, and for the 5th Parliament, you know, the 9th Parliament to be ushered in. I
see. I mean, will it be your expectation and perhaps even advice that these 4 people whose seats have been in contention perhaps should resign for the sanity of Parliament itself?
Well, the question of resignation is left to the individual MP. All right, they cannot be compelled to resign. You know, so for me, yes, but if I were in their situation, I would have resigned, because that is what the Constitution actually expects of me, right? If I am independent and I decide to join another party, I'm no longer qualified to describe myself as an independent. So I would have written a letter resigning so that I can contest on the ticket of a political party. Again, if I am in Parliament as the candidate, as the MP of a political party, and I decide that I have differences, deep-seated differences with that political party, as is the case with, the Honorable Aka, whose case I know really very well because I have been very much involved in trying to resolve, the impasse in Memphis Central. Okay, if I were in his case, the differences between him and our party are deep-seated. They are irresolvable differences. We have tried to persuade him, to back off, and he's not backing up. If I were him, in good conscience, I would have tendered my resignation as a member of Parliament and then gone on to, contest as an independent.
If the Supreme Court's ruling is an interference in the work of Parliament, should the Speaker abide by this? Should the Speaker adhere to the order from the Supreme Court?
Yes, he should. The reason is simply because even if a court order is wrong, it must be obeyed. Unfortunately, that is the position of the law.
Won't that set a bad precedent?
No, it will not set a bad precedent, because it is anticipated that the person affected by the wrong order will have his or her day in court to set that order aside. So disobeying the court order is not an option. And as a lawyer, I always advise my clients that though the order may be unpleasant, you may think that the court is wrong and so on, please obey it until we have been able to bring that to the notice of the court that it was wrong, and then have the order set aside.
Practically, on Tuesday, assuming that the NPP side decides to no longer boycott the activities of Parliament, comes to the House, do you envisage how chaotic it's going to be? Because I assume they'll go to the majority side of the Speaker.
I presume they would, because that is what they've been, saying all along. And I think they have been emboldened, by the ruling of the Supreme Court and the orders ensuing from that ruling. And I'm sure they will be going back to the majority side of the House.
And what will your side do? Where will your side sit? To the minority side?
Well, I'm sure if we are early, we can go to the majority side to sit until Mr. Speaker orders otherwise.
But it is chaotic. It spells a very chaotic scene come Tuesday.
Yeah, it does. And it does.
And is that helpful to parliamentary business, to the nation?
It's not very helpful. But as I said, before, all right, if we were conducting ourselves according to the principles and values of the Constitution, the chaos would have been avoided. But we are not doing so. We are basically conducting the politics of convenience, and that is what is creating the problem.
To think that there are issues that would be considered urgent, and the Supreme Court hasn't come to that decision to call some of these cases that have been described as urgent, to think that in the case of the SAL situation, the Supreme Court didn't make the argument of representation